and welcome to this edition of the Great Cases series. It's an initiative of the Vidhi Center for Legal Policy in collaboration with the India International Center as a part of the Working of the Indian Constitution, Stories and Scholarship series. I'm Dhwani Mehta and I'm going to be moderating the discussion today. We've had some wonderful discussions as a part of this series, and I know that there will be a lot of stories from our panelists, hopefully also many ideas for scholarship and advocacy that should emerge from our discussion. So I'm going to start by, throwing a few questions out there, which should give you a sense of what this talk is about. What does the Indian Constitution have to say about death, and why should we care about it? What should the law have to say about how we die? These are the kinds of questions that I hope to discuss with our panelists and with you as an audience today. As part of this series, what we usually do is we discuss an important landmark Supreme Court judgment, or a High Court judgment. Great judgments can come from any court. And in this particular instance, the judgment that we will be discussing is Common Cause versus the Union of India. For those of you who aren't familiar with it, I'd like to provide a very brief overview. As the title of the talk says, this case was about the right to die with dignity. It came out of a writ petition that was filed by Common Cause in 2005. And the petition asked for the legal recognition of advanced medical directives. Now, advanced medical directives, or AMDs, as I will refer to them during the course of this conversation, are documents in which an adult person can express their wishes or preferences about the kind of treatment that they wish to receive at a time when they lose the ability to take decisions about their own health care. Typically, they operate perhaps, in instances when one is terminally ill or in an irreversible condition where they cannot be expected to enjoy a quality of life that's acceptable to them. But advanced medical directives can also apply to other kinds of healthcare treatment. We already have them in India in the context of mental health care. Now, AMDs didn't have legal recognition in India at the time at which Common Cause filed this petition. In fact, soon after the petition was filed, the 196th report of the Law Commission of India said that these documents should be void, not recognized legally. And this stand was reiterated in a later report, the 241st report of the Law Commission as well, which was published after the Supreme Court had delivered its judgment in the Aruna Shanbag case, a case on which we will also have more discussion during the course of this evening. Even a 2016 draft bill that was introduced by the Health Ministry on the treatment of terminally ill patients refused to recognize advanced medical directives as legally valid documents. So this should give you a sense of why the judgment in Common Cause, which was ultimately delivered in March 2018, is such a remarkable one. Because it is the first time that not only were they recognized as legally valid documents, but the court recognized the fundamental right of persons to exercise control over their healthcare decision making, even at a time when they had lost their decision making capacity. So very simply, I'll explain the reasoning here again in a simplistic way. It's a very long judgment for anyone who cares to read it in the fashion of constitution benches of the Supreme Court. But there's a lot of interesting material there on the criminal law, on death and dying. The judges have waxed philosophical about these issues as well. But broadly speaking, the legal reasoning is this: that the Constitution under Article 21 protects the right to life, but that right to life also includes the right to die with dignity. And this includes the rights to autonomy and privacy as well. This translates into a right to refuse medical treatment, including life-sustaining treatment, so that even if the consequence of such refusal is death, that is protected. And this, taken to its logical conclusion in Common Cause versus Union of India, is that you should be able to exercise this right even at a time when you lose the capacity to make those decisions, provided that you have applied your mind to them at a time when you do have capacity and written down your wishes in a document. So this is how, very simply speaking, the court's thinking can be traced. And as I said, there's a lot in there about the criminal law, the common law, the difference between actions and omissions. And I hope to discuss that with all my panelists who happily have nothing to do with the law and are here as, in their professional capacity as healthcare providers, as community physicians, as critical care doctors, palliative care doctors, who will give us an insight into how the law interacts with practice. And I mean, judgments like this are very important, of course, for the principles that they lay down, but, they affect us in terms of the control they exercise over our daily lives. And this is a judgment that will affect each and every one of us. So I am sure that you will all engage with us closely on this particular issue. So there are a couple of other broad points that I want to make that I think will help guide the discussion this evening, and then I'd love to introduce our panelists and begin asking them questions. The other important things to remember about this judgment are that in addition to recognizing advanced medical directives, the court also recognized that life-sustaining treatment can be withheld or withdrawn from persons at a time when they have lost their decision-making capacity, even if they haven't made an advanced medical directive. So the principle here being that medical interventions can sometimes not be beneficial for people, and it is the prerogative of doctors to determine when this is or is not in the best interests of the patient, and for patients and their caregivers to also express a preference about whether such treatment should be continued. So this judgment is not only about advanced medical directives, it's also about recognizing when medical intervention is no longer useful or beneficial. And there are other cases more recent. I mean, there is one case in particular more recently that was up for discussion in the Supreme Court, which has brought an actual example to life. Sorry, that was a wrong choice of words. But there's the petition in common cause was a petition in the public interest. There wasn't a particular case that the petitioners had in mind. More recently, the parents of a patient who has been in a permanent vegetative state for over 11 years approached the Supreme Court to request the withdrawal of a particular kind of treatment, in this case, clinically assisted nutrition and hydration that he was receiving. And the issues that were raised here were one of when does providing this kind of care become a financial burden, an economic burden, a physical and emotional burden, and are these valid considerations in thinking about when life-sustaining treatment can be withheld or withdrawn? And again, I know that there will be very interesting perspectives from our panelists today. So these are all the kinds of issues that I hope to discuss with you. And so I'd like to now begin by introducing our panelists. We have Dr. Raj Mani here, who is the Director, Clinical Services and Pulmonology at Yashoda Super Specialty Hospital, and more importantly, a champion of end-of-life care in India, the chairman of the End-of-Life Care in India Task Force, and a relentless, tireless evangelist for, doing medicine in a responsible, ethical way without fear of the law. I'm very glad to have him here. Thank you, Dr. Mani. We also have Dr. Sushma Bhatnagar, another fearless pioneer who's the head of the Department of Onco-Ansesthesia, Pain and Palliative Medicine at AIIMS, New Delhi. And she is really the architect behind the fact that AIIMS has a well-thought-out end-of-life care protocol and policy, and is actually walking the talk and providing the kind of care that the judgment intends that doctors are able to provide to their patients. So thank you very much, Dr. Bhatnagar, for coming here today and talking to us about your experiences. And then we have Dr. Parth Sharma, who describes himself as modestly as a community physician, public health researcher, but who is doing some truly fantastic work on the ground, building a body of knowledge about palliative care, the need for it, and what attitudes in the community are to it. And I know he's going to have some interesting perspectives and stories to share with us today, and really looking forward to hearing from you. Thank you. So, Dr. Mani, I'm going to start with you first. And the question I'm going to ask you is perhaps going to request you to give us a brief history behind the case. I mean, I've tried to give a little bit of an overview, but I'd like your perspective on why, what is a seemingly routine medical question in other countries, which is how should life-sustaining treatment be withheld or withdrawn? Why did a question that, I mean, it seems to be the province of medical knowledge and expertise, how did that end up in the courts in India, and why did it become a legal and a judicial question?
Wow, that's a wonderful question. Yeah, I'm an intensive care specialist. So all around me every day there were patients on various kinds of life support. Ventilator is one such. There are many other types of life support. So one striking question in the midst of all this is whether somebody is benefiting from the life support or not. There are people in terminal illness, there are aged individuals, there are people beyond cure, beyond the advances of medicine, but who are also, as a matter of course, being hooked on a ventilator or on other interventions, aggressive interventions, which do more harm than good, particularly to the patient in question. It makes death very medicalized, very undignified, very interventional, and to the family and the finances, of course. But finances are not the main focus here. The main focus is the ethics of these interventions, the right and wrong facet of medicine, because every intervention must have a boundary, isn't it? It can't be for all people at all stages of illness. So that is a clinical judgment. Basically, it's a clinical call whether we are crossing the ethical boundary. And the clinical call is not just unilateral with the physician. It is together with the values and wishes of the patient or the representatives, isn't it? So that is the clinical perspective. And what brought to focus in my life, that we have to embark on this journey of correcting this anomaly in our midst. Everybody receiving aggressive treatment, as an imperative. And then we framed in 2005 in the Indian Society of Critical Care Medicine, they appointed me chairman of an ethics committee which framed the first guidelines for the critical care specialists of this country. How and when to recognize the limits of interventions and how to communicate that in an understandable language with the family, and together take a call when not to overdo things, when not to overtreat, and to then shift the paradigm, the focus, on the comfort issues of the patient. And of course the family as well, the suffering family, because there's a dying person and there is a grieving person. So both are coming in the ambit of care, which was focused just on interventions aimed at disease. So when we framed this guidelines, the question always came as to what is the legality of these decisions. See, that's how the legal perspective overcame the medical perspective. In our country, we had a total vacuum on these matters. In the Western world, of course, these calls are taken by the clinician, but there are frameworks, there are legal frameworks for whenever there is a question, whenever there's a dispute, whenever there's a confusion, there is a legal framework. In our country, there was no legal pronouncement on this issue at all. There were some indirect references in the Gyankor case, which was a case of suicide and case was of abetment to suicide. But there, the right to die, take one's own life was not sanctioned, but the right to die in dignity was recognized. That was the only indirect reference. And then the Indian Society of Critical Care Medicine went to the Indian Law Commission to frame legal guidelines. And that's how, the legal side of things, it's a three-legged stool. There is a medical question, ethical dilemmas to resolve, and there is legal frameworks. What has happened is, it's the legal aspect of things have overwhelmed the other two as of now in our country. But originally, it's a human problem. It's a human problem intersecting the medical scenario. So this is how we came to regard law as a third leg of the stool, and then we approached the law, and as Dhwani said, the Indian Law Commission did not recognize the AMD to be safe in India. It is subject to misuse, so they discarded it. So it took a long while until the 2018 judgment to get the right back to us. The draft bill never saw the light of day in Parliament. So we had to wait for other judgments. We'll come to that presently.
Thank you very much, Dr. Mani. I mean, again, it's interesting to note that it was medical professionals who approached the Law Commission of India requesting this kind of legal framework, but how the law took over and what judges and legislators have made of these medical questions is, again, something we can talk more about. So, speaking about the kind of journey that we've had, Dr. Sushma, how important, do you think in your practice, what is the common cause judgment? Did it have a significant impact? Has it changed the way in which you are now able to provide palliative care? Has it changed the influence, the perception of palliative care amongst medical professionals themselves?
Thank you, Dhwani. Thank you for this question. And what I want to say that I start my journey as a doctor before AIIMS and after while I was in AIIMS. So before AIIMS, if I consider that, if I recall that every patient, those who are, we were not knowing anything about all such things, that if patient is in end stage or patient is inevitably dying, we should approach this patient in a different manner. We were not knowing, and this was not our fault, and this was not there in our. Nobody has taught us. No, this was not in our curriculum, so we were not knowing. But after learning about palliative care, after understanding that inevitable, when end is inevitable, we need to approach patient differently. I think we started working at AIIMS, and after working in AIIMS, it was not a it was not a tough task, and it was a very smooth journey. That because a lot of things work on the confidence and on faith at AIIMS, and we used to talk to the patient. So what I have realized, that communication and making the patient understand, it was the key of providing good end or dignified end to our patient. This was very easy. This is very easy as far as cancer patients are concerned. We make them understand, and people think that if end is inevitable, is going to be end, and they understand. But when it comes to the non-malignant diseases, it was so tough, because when I still remember that when we were working for end of life care policy, I think Dhwani was part of us, and we have called almost 16, 17 experts from AIIMS, and it was I think 2-3 meetings just waste. We couldn't decide anything, because nobody was ready to believe that there is something called providing dignified end in non-malignant diseases also. Although they were practicing, but they were not ready that it can become a policy document for AIIMS. So finally, I think with repeated meetings, with Dhwani's presence and by talk, giving them examples, giving them references of critical care medicine, ICMR paper and everything, I think we have come to the conclusion that yes, this is and we framed our end of life care policy of AIIMS, and this was a real great success. And again, it was, I can say that it is 100% implemented in cancer patient, but now it is getting rapid recognition. All other departments are also discussing GI medicine, GI surgery, emergency. Everybody has keep discussing this, and they are practicing as well. So now, after this common cause judgment, you have asked that how this has made any difference. So I have not taken any note, but definitely the awareness about advanced medical directive, awareness about legal will, definitely created a huge impact all over in the medical community, and definitely given an empowered doctors, and that because this is more important in different private sectors where people are very afraid that but this is also true that if we will communicate properly, if there is everything is documented, and if you are giving honest information and realistic hope, this will not happen, because this is just an emotional statement which I keep saying that this doesn't happen, but this can happen. And this, the judgment has really given an empowered lot of lot of private hospitals, and I think Dr. Mani, me, and everyone remain busy in these days and discussing always advanced medical directive. This has become a topic of discussion. Everybody wants to know more and more about it. Just now I finished that before coming over here. Indian Medical Association doctors, they were there, and we discussed about advanced medical directives. So this is definitely giving the wings, giving the hope that definitely India will be a place where we will be able to give dignified end to our patient. Only thing, communication role will not go away. I keep saying that even if you will have an advanced medical directive, even you will have all legal documents, but if you will not communicate properly, there is no, we can't say that without communicating we have just taken notes and it cannot replace your good communication. So we have to teach our doctors, our youngsters, our nurses how to communicate properly in every circumstances, in various situations. Thank you very much.
Thank you, Dr. Sushma. Absolutely. I mean, I agree that the law is acted perhaps as an enabler, as a catalyst, but it can, and hopefully it will be a catalyst for doctors, healthcare providers to continue having these conversations and communicating with their patients better. Whereas, before there was fear of legal liability. I mean, there still is in large sections of the medical profession, but hopefully this judgment acts as an enabler to break down those barriers. So thank you for that perspective from the medical and the palliative care community. Parth, if I can turn to you and ask you, perhaps, I mean, I know you're a doctor, but you have a different kind of experience interacting with people in the field, working with persons with life-limiting conditions, terminally ill persons. Could you talk a little bit about that experience and, maybe specifically in terms of whether the law is relevant at all to such patients' understanding of their illness and the treatment options available to them? And just to, to bring up a point that came up during a discussion that we had yesterday, is that advanced medical directives are still seen by some people as an elite document, as the person put it yesterday, that they are accessible to only urban educated persons and have no application or relevance to people in straitened socioeconomic circumstances. So could you talk a little bit about what your opinion on that is as well?
Thanks, Sonny. Thank you for inviting me for this discussion. It's an absolute honor to be here today. To give some context first, I represent a community that I'm not a part of. I come from a very elite background. I have had a very privileged life. But today I'll speak for people who are not here in this room and not on the panel, which is something which we have to realize. I've gone across the country. I've gone from Kerala, Karnataka, Northeast, Assam, Uttar Pradesh, Uttarakhand. Everywhere where I've gone, I've seen suffering, and I've seen people speak one language. We're talking a lot about one nation and everything. There's one nation, one language, and people have been speaking this language for decades, and we've somehow ignored it. We are actively ignoring this language, and that's the language of suffering. And this language sounds the same everywhere. We think of Kerala having a very good public health system. I've seen intense suffering in Kerala. I have seen intense suffering in, obviously, in areas where public health system practically doesn't exist, like in North India. And when I witnessed this suffering, I've also worked in emergency, I worked in ICU, I worked in oncology over my limited experience, but I've seen the suffering everywhere. And with witnessing that suffering, there is one thing which comes along with the suffering, and that is the desire to not suffer. You know, when somebody is suffering, they have two questions in mind: why am I suffering, and when will the suffering end? And that desire is closely linked with this intense suffering. I'll share some stories from the field. Yesterday, I visited one lady who is 80 years old. She's blind. She was disoriented. Her 66-year-old son was taking care of her. And, sir talked about finances. This is not about finances, but their biggest expense was buying that diaper every day because it is too expensive. And their income was only 5,000 rupees a month. And, that lady was disoriented, but she said only one thing again and again. Doctor, mujhe dard ki dawai de do. That's all she said. She was repeating this over and over again. She's not saying anything else. You ask her name, what's your name? She's not telling it. But she's going on over and over again. I did my MD thesis in oncology. I was working with patients with oral cancer. One day, one patient's son, and he said, my father begs me to kill him every day. Can you please do something about it? Can you please... because something as basic as pain relief is not accessible in this country. And I'm not talking about morphine. I'm not talking about something, high-end fentanyl, which pharma industry is pushing. I'm talking about basic things like NSAIDs, like diclofenac. In my health center, it's been out of stock for months. And, I've been buying from outside to give to my patients. Our health system is extremely fractured. And so the question is, how does one not suffer in a health system like this? In a country like India, where the public health system is apathetic, it's just ignored, how does one not suffer? And that's when, when the public health system has been neglected throughout decades since independence, when it's been neglected, then it becomes a responsibility of the legal system to make sure people have those rights which the public health system is not ensuring them. And even if they don't have a dignified life, at least they can have a dignified death. And I believe this is the worst kind of violence you can inflict on anybody. Because, it's like my professors used to say, what causes death in tuberculosis? And it's not the bacteria. It's the lack of medicine. It's the lack of food. It's apathy, which causes death. And it's similar now. This is the worst kind of violence we can inflict on anybody. You push them to the limit where they develop diseases and you leave them alone to suffer. And because those people are not here today, the people that we are talking about, I just want to put you all in their shoes for a minute. So I request everybody to close your eyes, if you're comfortable. Close your eyes and imagine as I speak. Imagine you are lying on a bed in a one-room apartment. Imagine that the right side of your body doesn't work. You can't lift your right hand. You can't move your right leg. You can't speak. You have a tube in your nose with which food is being pushed thrice a day. And you've been on that bed for 6 months. Your back hurts like anything, but you can't speak. And it's possible you might not ever get up off that bed. And that's the bed where you eat, where you sleep, where you pee, where you poop, where you do everything. That's home for you. And now with a show of hands, would you want to get intubated or go on mechanical ventilation if you crash at this moment? Anybody? Next imagination. Now imagine yourself to be the caregiver. Now imagine somebody you love is in that position. Would you want them to live an extra day in this condition? A show of hands. And this is what is happening in the case in Supreme Court, where, So when we talked about, is this relevant for people in my community? Yes, it is extremely relevant. Because you talked about treatment options, and they don't have options. Their one option is to live a life of suffering. Their second option is to die suffering. They don't have treatment options. I met a lady, a person today, 80-year-old again, and he saw me and he said, take me with you, keep me with you. Take me to your house. He was disoriented. He was psychotic, but that's all he could say. I don't want to stay here. Take me with you. And the treatment they were on was multivitamin, because the wife was 75 years old, and all they could get care from was a quack who was just outside. So the quack was giving them very expensive multivitamins, very, very expensive multivitamins. Because multivitamin is a $1 billion industry. You can give any, I can prescribe 500 rupee one tablet multivitamin also. So that's the treatment they were on. So when we think about treatment options and advanced care planning, in the community, it doesn't work. And most of the times, when we think of public health programs and policies, we always talk about that Gandhiji's line, it should reach the last person in the line. But there are countless people who can't reach that line. They are stuck at home. And that's when we have to go and get to them. And I feel that's where palliative care and community medicine comes into the picture. But over the past 2 months, I've been going around searching for these people who are stuck at home. Why are they suffering? What can we do for them? And every time I explain this judgment to them about the Supreme Court has said that you can make a document for yourself, and then I explain the entire thing to them and I ask them, do you want it for yourself? And they say, yes, we want this document. So like you said, we had this discussion yesterday also. I'm afraid it'll become an elite concept. Like most of the services in this country, legal, health, whatever, it's accessible to only that 1%. And I don't want this document to be accessible to that 1%. This has to reach communities, and which is where, people like you, Roop, Rajani, and sir and ma'am, people like you all give me hope that, we can work together to make this as accessible as possible.
Thank you very much, Parth. I mean, that was a really, moving description and, sobering reminder of the fact that healthcare doesn't get to the people who need it the most. I think, Dr. Mani, if I can turn to you now, this is, we have this perspective about lack of access to healthcare. And you've also always talked about the burden imposed by disproportionate medical care. And that is something that you struggle to, explain both to medical professionals as well as to judges and lawyers. And you were on this, you were in court while this, the case was being argued and these guidelines were being modified. Just before I ask you the question for the audience, I wanted to speak briefly about the guidelines that the court laid down in this case for the implementation of advanced medical directives and the withholding or withdrawal of life-sustaining treatment. So the process requires 2 boards of medical experts of 3 doctors each, with both boards having to sign off on the fact that further medical treatment in this case would not be beneficial for the patient. In the second board, the first board can be composed of doctors from the hospital at which the patient is. The second board requires a doctor to be nominated by the district chief medical officer. And finally, when both these boards agree, the treatment can be withheld or withdrawn after intimating a judicial magistrate. The guidelines were far more complicated before this in 2018. And that brings me to my question, Dr. Mani. Why is it that, and they were ultimately founded on distrust, suspicion, both of doctors, of caregivers. The constant trope was one of, collusion so that patients could be killed off hurriedly for, an imagined inheritance. So, why do you think, Dr. Mani, how do you think doctors can address this perception? What is the language that we need for the legal community and the medical community to, effectively talk to each other? Because as you've pointed out, they are now so inextricably intertwined. Doctors look to the law for guidance. The law should be informed by what responsible medical opinion has to say, but it's taking a while for the twain to meet. So, what would you have to say about that?
I think we are facing barriers of understanding at 2 levels. One is, what Parth said about not having access to medicine. What the judgment is about, where you have access and where you have excess of it. Where there is a chance of excess, and that will affect everybody. Those who have no access, of course, we should not confuse the palliative care with it. Palliative care everybody deserves, and palliative care is a movement, parallel movement. This movement is another, where people are suffering due to imposed suffering by medicine, by advances in medicine, and even those who can only partially access it are affected by it, and their straitened circumstances get only worse with it. In fact, there is the National Sample Survey showed that 40% of families go below poverty line after 1 admission to the ICU. So it is not, they are not so separate, access and no access. There are a lot of gray areas in between, and all of them suffer on account of suffering imposed by advances in medicine. Now, this aspect has not gone across to the legal circles in this country, that there is an imposed suffering. We are not discussing that. What we are discussing is the right, the pro-life and anti-life sort of issue. It is not that. Nobody is denying the right to live to anybody. Only the right to die in dignity is being restored and reminded and defined. And this needs dialogue, on a freewheeling dialogue between those who control the legal policies and the medical profession, because it is not that law can be separate from the medical perspective. You can't impose some rules on the ground, on the doctors, on the caregivers, where you're not familiar with the circumstances. So what has happened is, they are making policies with realities they are only partially aware of, and we have not had a chance to get it across. So there are misunderstandings at two levels. The pro-life, anti-life issue, okay? This has got nothing to do with pro-life. This has got something to do with imposed suffering by advanced medical technology. And that is relevant only when you have access or some partial access. You don't talk about community palliative care here. This is a different aspect. Will impose on that also, because even in the community, those who don't have access, they have aspiration of access. And the caregivers at that level are also affected by this overall culture of aggressive treatment towards the end. Okay, so the overall culture must shift to appropriate caring when the end comes. So that is where we are making a difference. So this is not elitist at all. It affects every family. So I want to make that very clear. This is not elitist, one bit. It affects the last person. Now, why is it that the legal profession is looking at the caregivers, the professional caregivers and family caregivers with suspicion and the idea of collusion to do a patient in? I mean, this, in 40 years of my practice in the ICU, I've never come across this. Okay, I've never dreamt, never imagined that such collusion could take place. There can be misuse of advances in medicine to the detriment of the patient and the family. That is very common. That's what we want to address. But not a collusion with family and doctors. Withdrawing. They won't bring the patient to the hospital at all. If they were intention not to help the patient to live, intention to do the patient in, then why would they bring to the hospital at all? So there's a major disconnect with reality on the ground, I believe. And that is why this excessive caution in framing rules, see the principles that they reiterated in this 2018 judgment are really laudable, and they are up to date in the, in this field in the world. But the recommendations or the procedure recommendation are very outlandish. They are not very strange. You can't have 3-level and 2-level decision making. That doesn't happen in any other jurisdiction. Dhwani and I, we researched into this. There are multiple countries, I think 17 odd countries, jurisdictions were looked into, and all of them only emphasize the medical judgment and the communication with the family. And that is only 2 or more physicians. It's not the 2-level 6 physicians. That is an overkill of regulation. So if you can't kill the concept, which you brought out in the principles, through the procedure, visual I mean, throttle, it's a action on the ground. It's, you know, it doesn't become actionable. So I think it is due to the culture of lack of understanding of the needs of the dying and the limits of advances in medicine. Okay. Now, this lack of understanding exists in the judicial policy making as well. I think that is the root cause. And we have to speak. As we speak to the community, we have to speak to the judicial policy makers. And then this can be bridged and we can have a more pragmatic, workable procedure.
Yeah, absolutely, Dr. Mani. And I mean, we saw many examples of confusion, especially in terminology around the idea of euthanasia, active, passive, withholding, withdrawing. A lot of these concepts were quite muddled in the minds of, the judges who were hearing this case. And there's obviously a lot of work to be done in bridging this gap and communicating what is obviously a very complex issue simply and clearly to to the public at large. Dr. Sushma, again, to building on from the difficult guidelines that Dr. Mani talked about. I mean, I know we've managed to simplify them somewhat, but what is the advice that you would give hospitals and doctors who want to implement the guidelines that the court laid down in Common Cause? Again, as someone who helped set this up at AIIMS, we've got Dr. Sharma and Dr. Sood from Gangaram as well who are trying to do the same thing. What are the steps that should be taken in operationalizing this procedure?
Thank you, Dhoni. Actually speaking, guidelines have been framed just to. Now it is guidelines framed just to. We keep saying that now there is a legal backup. We feel empowered that their guidelines are there. But all the hospitals should follow these guidelines. But again, I will keep emphasizing that we can make 2 boards, 3 boards, 5 boards guidelines. We can keep on making boards and we can keep on taking signature on advanced medical directives or living will. But if we will not explain, if we will not make them understand that what is happening to them, if we will not communicate with them, I don't think that there will be any role of all this, because people will feel again angry if we will not talk to the person, if we will not communicate properly. They will feel same angry and there will be a lot of confusion. So by making these rules, I will be focused answer I'll give, that by making these guidelines, definitely hospitals will feel empowered. But again, understanding a patient, communicating well to the family members and patient, and there should not be any collusion. And Dr. Mani was saying, we are not against technological advancement. Technological advancement are good for the patient. But when technological advancement becomes suffering for the patient, I think this is what we have to explain. And if we will not explain, this will happen that a poor person will keep feeling guilty that because I was not having money, that's why my patient has died, because I could not give an ICU bed. But who will explain that patient that it was not required? It was a simple pain management and simple care was required, and we were providing it. So guidelines are definitely a tool or a mode that we will feel empowered that there are guidelines, and every hospital up till now definitely should make. But I am again saying that without having a clear-cut understanding of your patient, without a clear-cut communication, without using when to use technological advancement, and by using, I think this was what I was remembering. In my last question I said that in my medical curriculum I have not learned, but I have learned principles of medical ethics. If you will, any doctor will use principle of medical ethics. They will automatically follow all the guidelines and all the palliative care, that they are not going to harm the patient. They will not overdo. They will not prolong suffering. Everything are there in the principle of medical ethics. And last principle says that I will use my resources judiciously. Automatically everything will come. So I think guidelines are there, all teachings are there. We have to just imbibe it. We have to make a system definitely in every hospital, especially in these days, a lot of things are happening all around. But I'm saying that, as Dr. Mani said, 40 years mein kabhi nahi hua. Even I can say that even in my lifetime, I have never felt that any patient is planning to do anything wrong against us because his patient, his loved one has died. Because we have communicated well. For our this thing, we have documented well. We write everything, whatever we are talking to the first patient, but sometimes we think that taking a signature will be an emotional burden. We don't ask them to sign, but we document this. So this is enough. I think building a confidence and lack of trust is becoming a huge problem between doctor and patient. And if we will develop that trust, I don't think any problem will come. Thank you.
Thank you, Dr. Sushma. I mean, it really points out the fact that communication is key. And that's, this is communication between doctor and patient. But I want to, again, given that this is a discussion about a great case, I want to come back again to the question of communication between patients, lawyers, and the courts. And so, Parth, we talked about the recent case in the Supreme Court where basically communicating with the court failed. We failed to make the court understand that continuing artificial nutrition and hydration through a PEG tube for a man who had been in a permanent vegetative state for 11 years was not active euthanasia. It was not killing the patient. It was not starving the patient. In fact, withdrawal done in the appropriate way with the right kind of neuropalliative care was the right responsible course of action. Why do you think we failed to communicate that? What is happening? What can we do better to change the public narrative about this, especially this perception about euthanasia?
Thanks, Vani. I think the core problem is our obsession as doctors with cure and with prolonging life. I think that's the core issue. Where practicing medicine has been reduced to parameters where humans are seen as normal saturation above oxygen saturation 94, blood pressure this range, your blood tests in this range, and that's what happened with this case, right? I mean, they saw him as a set of parameters which was normal, and he was not requiring external support. In the terms of saturation was normal, so no oxygen. Mm-hmm. And in our culture, we see food as a form of love. When we give food to somebody, we tell them we love them. And that's what happened in this case as well. Withdrawing food was seen as something evil. But the question then is it morally correct to prolong suffering? And that's not how this case was seen as. Again, I think because the medical system is at fault, because the education system is at fault. And the problem in our health system also is that when somebody is diagnosed with a life-limiting illness and a cure is not possible, health system goes away from them. So if and only they are in acute illness or they're acutely suffering or acutely dying is when in a hospital they'll get a bed. I have worked in the emergency and I was there during COVID when the second wave of COVID was going on, and people would come and then I would be like, oh, they're almost going to die, take them home. Right? We can't save them. We don't have a bed to save them. But then who takes care of these people when they're sent home? They're still suffering at home. I have been a part of the problem. And I think that's where palliative care steps in, and there is a huge misconception that palliative care is only end-of-life care. Palliative care is anything to do with suffering. It could be economic, financial, emotional, physical, any form of suffering. Buying somebody medicines because they can't buy it is also palliative care, because we are ultimately addressing suffering. And I think the problem with our education system is now that palliative care is a separate branch, which I personally believe, people might not agree with me, but palliative care should not exist as a branch, because palliative care only means taking good care of people, which every doctor should do. I mean, why do you need a separate branch called palliative care? It's an approach that every doctor should have and every human should have, and I think that's where we are very wrong with our health system. Coming to Harish's case, right? I mean, it just highlights again how messed up our approach to taking care is. This is something I often tell my students as well. It's called health care. It's not called health cure. and somehow we forget the care part of health. And the scenario which we did right now, when everybody closed their eyes and imagined to be a person with life-limiting illness, that was only a physical part of the disease. Again, WHO says it's physical, mental, social well-being. I didn't say that that you don't have anybody to look after you. You are lying there alone, and there are probably rats around you. Nobody would clean you. So that's the social part of the disease. I didn't tell you that you're in severe depression, that you also have a 2 lakh debt. Your kids have dropped out of school and gone into generational poverty. I mean, those are social illnesses. And so this was just the physical part. None of you raised your hand. Imagine somebody who's also suffering from the social and the psychological pathologies. And this is a form of sort of thinking which is not being inculcated in the legal system, I think, where again we are seeing the good to be to save life. And as a young doctor, when I just graduated from MBBS, I remember saying that, I'll save everybody's life. And then I worked in oncology for a year, and people were dying every day. And then I was like, okay, I'll try to save everybody's life. Then I went to emergency, and COVID struck, and now 8 people are dying in my shift. And I was like, I'll try to help everybody. And then I came to Delhi, and I'm seeing so much of suffering, and I can't even help everybody. What do I do? So this is that, somehow this has to be brought into our education system and our legal system as well. And we have to ask deeper questions. We have to ask, is our medical education good enough to take care of our people? Is our health system good enough? Is it well funded to take care of our people? And these are the core issues ultimately, because unless and until we have access to basic care to people, we can't talk about something like palliative care, which requires even more resources. We can't talk about advanced care planning. And I think advocacy has to go along all these lines, and more such stories need to come out. This case in Supreme Court, that person was very fortunate it reached the Supreme Court.
Yeah.
I know 50 people in my community. I know actually 140 people in my community who are just like him. We were able to raise funds for him, but what about the other people who don't even hit the news, right? What happens to them? So these stories need to come out more and more often.
Absolutely. And I think, the court's job is to actually, of course, it does do justice in each individual case, but it also has a duty to lay down the law responsibly. And, the solution that it found in Harish Rana's case, which was to get the government to provide care to the patient, is, might have been seen as providing humanitarian relief of a certain kind in that individual case, but it's not something that can sustainably be replicated, as you said, for all the patients in your community. So we do need and that's why Dr. Mani and Dr. Sushma, the Indian Society of Critical Care Medicine, the Indian Association of Palliative Care, filed an intervention application that wanted the court to take a principled stand on recognizing that withdrawing this kind of artificial nutrition and hydration was a form of withdrawal of life support and was medically required in these circumstances. So we need the court to engage with those kinds of questions as well, and that's the advocacy that the both of you have been engaged in also. Yes, sorry, Dr. Mani, you wanted to come in here?
In the Supreme Court, the point was totally missed in Harish Rana's case. It is not just the logistics of looking after the patient, and they missed the main point of, from the patient's perspective, 11 years of vegetative state. From the patient alone, now leave the family. Is it something to be just prolonged forever, just like Aruna Schonborg? Now, we went through a whole case. In the case of Aruna Schonborg, in a similar situation, she spent, I think, 36 years like this. And the judgment was made that so-called passive euthanasia, that is withdrawal of nutrition in that case in particular, is legally valid and constitutionally valid. That decision was not taken in that case because the next friends, the nurses who were looking after, the caregivers, didn't want to take that call. Because somebody has to represent you, and the representatives have to consent to this decision of removal of the nutrition. In case you don't have an AMD, then it is a call between the medical profession and the family. So there was that procedure was ignored totally. I mean, there was no medical panel sat for this case. What is feasible? Now, that option is available to us through the Aruna Schonbock case and all these common cause and the simplification judgment, that withdrawal decision of what is supporting the life. In this case, is medically supported by nutrition. And that is, in principle, validated by the Supreme Court itself. So that preceding judgment, prior judgment, was totally ignored. And this main aspect of suffering for the patient and the family. Now, just prolongation through using state resources is not the answer at all. And that can't be replicated in other 150 cases that may be there. And so it lost an opportunity to drive home the point that in a given situation like this vegetative state, it is feasible, it's medically and judicially correct to withdraw nutrition in the proper, observing the proper medical procedure in doing so, using sedation and other support during this process, which may take 10 to 14 days.
Absolutely, Dr. Mani. I will come back to the panelists for one last, closing remark at the end, but I thought that we should take a few questions from the audience now. And yes, please just raise your hand and, we'll try and get a mic to you.
Hi, my name is Ajoy. I was just curious as to, so recently the United Kingdom passed the assisted dying bill, and I'm a reporter, so I covered it in a story, and frankly, I wanted to know your take on, is there a real difference between a lot of these tags? Because after getting through a lot of the legal minutiae, if I can sound a little reductive, it seemed like the difference between passive euthanasia and assisted dying was the difference between an injection and pulling a plug. So is that another way that the legal minutiae seems to be getting in the way of a lot of this?
Sure. Dr. Mani, do you want?
They are chalk and cheese actually. All right. Withdrawal withholding decisions are considered decisions not to intervene. You understand? But physician-assisted suicide is actual intervention. Giving a lethal injection or drugs or the means for the patient to take those lethal medicines. So we are a little light years away from that sort of respect for autonomy. That's an extreme form of respect for autonomy. So we don't need to discuss physician-assisted suicide in this country yet when we don't have the basic background of not intervening. Now, pulling the plug is a term which has to be understood as not intervening. Okay, you having already intervened, you take a decision not to continue with that intervention. That's what withdrawal is. It is not injecting something or actively ensuring death of the patient. It's not that. It is not prolonging the dying process. Neglecting to, in a considered way, neglecting to intervene medically. Okay, that is so different from active euthanasia, which is actually, there is an intention to kill, intention to put the patient out of misery by a lethal drug. Okay, that definition is very narrow, and that has to be understood. If we mix up definitions, we'll never understand, which is one of the other barriers of communication with the community and with the legal profession now. That the definitions are all fluid and mixed up, and we must take care. We do have an ICMR document which has a consensus definition of all these terminologies, 25 of them, and all our ISCCM, IAPC guidelines also carry these definitions.
Hello, sir. Sir, I just want to ask whether it's a passive intervention or active intervention. We may change the terms, but the situation is, as we can revert, is assisting the patient for the suffering. The second, my issue is basically, I'm from the psychology background. what effect it is going to have on the people, those who are living, friends and family? Those who are living, like friends and family, associate people.
You know, we can't mix up the terminology as passive and active being the same. That's not true. In fact, the term passive euthanasia itself is being outdated, okay, in the world. We don't use that. We call withdrawal and withholding, which is the fact of the case. Now, by adding the term euthanasia and mixing it up with active euthanasia, calling both the same, now, that doesn't help us in any way, because the intervention with a life support is an imposed one. It is not a natural one. Objective is not the same. Objective is not to put the patient to death when you don't intervene. The objective is not to do something inappropriate. Okay, that is where it is. Not to do something inappropriate. You don't take a patient to the hospital in the terminal illness. That is not an active euthanasia by any stretch of imagination. We all do it in everyday life. So this is the misunderstanding we have. Now, active euthanasia, very few countries are having in the world, 17 countries, but then withdrawal, withholding, large number of countries are, and without even legislation. So this is a much different activity where you think that a certain intervention is not going to help the patient do more harm than good, or just prolong the dying process. Whereas active euthanasia is by voluntary request of the patient. This has to be understood. It is not involuntary. There is no involuntary active euthanasia. By voluntary request, in certain situations of incurable illness and which involves extreme suffering, the prospects of suffering to the patient, so that is under certain regulatory mechanisms. That is introduced in many countries and about 10 states in the US. So that is not the same as withdrawal and withholding. What we have got in terms of law in this country is for withdrawal and withholding, which is confusingly termed as passive euthanasia by the Supreme Court, but we should drop that term, so that this confusion with active euthanasia is jettisoned once and for all.
Yeah, and if I may just add, the legal perspective here is that a medical intervention is something that, without the consent of a person is actually, in common law, was understood as assault. And therefore there is a duty not to provide that intervention when it is not in the best interests of the patient. And that intention and that characterization of a medical intervention makes it very different from the active process of administering something with the intention of bringing about death. Here and then.
I'm Dr. Kinshaki Jain. I just needed to understand the concept, the need behind adding shared decision making even when the AMD is in place.
So I think there should be always shared decision making, whether it is AMD or no AMD. Whenever we decide about a human being, especially when it is end is near, I think it should be shared. And when it is shared, we develop a confidence between a person and a family members and caregivers. And that will give the answer that what caregivers will think, that if I'm not giving food or that will give the answer. So it should be always, I will keep the shared decision making on the top, because this is the thing which is required in medicine. This is the thing which is required. Although advanced medical directive is going to have a very good role to empower those who are afraid or those who are worried about the legal aspect, but definitely shared decision making is important, and it gives a lot of confidence between you and patient.
Ma'am, it's not about the patient, it's about the relatives actually. Sometimes the patient...
I'm talking about shared decision making. It should be always with the caregivers, patient and you.
But if the patient doesn't want, if he already has advanced medical directive in place that I do not want unnecessary prolongation or unnecessary disease-directed treatments at a point where the primary medical board feels it futile. But the caregivers, because we deal with it day in, day out, the caregivers keep on pushing. So then what is the utility of AMD then?
I think it's a very good question. You know, I'll try to answer you, because when we execute the AMD, the patient is usually not expected to envisage the exact situation in which it is applicable, okay? That is a bit variable. And that is one reason why we need again to relook. Although you have an AMD, you have the patient's values and wishes well documented, there has to be another aspect of ethics which we had to add, which is beneficence and non-maleficence, okay, which is from the physician side. The physician has a duty of care to see whether it sits well, you know, that AMD sits well with the clinical situation to hand, because that may not be exactly envisaged by the patient. And that is why that has to be communicated with the family and with an appointed proxy, or if there is no AMD, but the family is able to tell the values and wishes of the patient. Both together have to have a dialogue and have a considered decision. You know, these decisions are not just automatic translation of an AMD. It's a considered, the court also says it's a result of cogitation between the family and the physicians. And that is the principle of shared decision making. And I agree with Dr. Sushma that should be the uppermost in these decisions.
My name is Sampath Kumar. I am a retired cardiac surgeon with 50 years experience from All India Institute. The entire discussion should be centered on 3 C's: communication, compassion, and cooperation. Now, I am a surgeon and I can relate to you a problem, a simple problem. I am operating and I recognize the fact that the patient is unlikely to come back to life. I cannot leave the operation theater and go and communicate. I have to get an emissary to do that. And sometimes communication becomes a problem over there. Secondly, please recognize that the person whom you're talking about, his life and his death, he is incommunicado. He cannot communicate to you in his critical state that he wants to live or he wants to die. That communication has to come from his family and what they have previously decided and discussed. And thirdly, medical education in this country does not include communication skills in their curriculum, which is a very pathetic state. I tried to introduce it in the All India Institute and they refused, but it was introduced in the Delhi University as a part of the curriculum. In developed countries, it is mandatory that the student who has to pass the MBBS examination has to pass the communication skills exam also. Finally, it is cooperation. Now, the hospital has to provide you some additional help in a case like this to make a decision. I am capable of making the decision on inevitability of survival in a particular patient. I can recognize those signs. But how do I tell the patient's relatives? How do I communicate with them? And what is their reaction? Many of them would say, you did not do enough to save my patient. Many of them will say, thank you, doctor, whatever you have done is good enough. We accept your decision. But those are situations which the doctors have to face in their daily activities. And it's a dilemma. The judiciary cannot solve this problem. The medical science can recognize the problem, and it has to become compassionate to make the correct decision in a particular patient.
Absolutely. Thank you for that, Dr. Kumar.
I will not get into technicalities and legalities. I think the doctors, the competent doctors, should be given a free hand in this country to approach the Supreme Court. Up to how many weeks an abortion can take place. I don't think people, for such simple procedures. We are talking about end of life. Even for procedures like abortion, why should one have to knock the doors of the High Court and Supreme Court? I think this decision should be best left to doctors, competent doctors in the hospital. Similarly, I think, as Dr. Saab has just mentioned, I think after a certain age, a person should write down his will. If such and such medical condition occurs to him, I think what procedure, the end of life, what kind of treatment he should get, that should be specifically mentioned, and I think it should be notarized or whatever, that would, I think, go a long way in taking quick and fast decisions. That's all. Thank you so much.
Thank you very much. We have a few questions on that side, please. And you can pass the mic ahead after your turn.
Yeah, so in a way, my doubt is a combination of the last three observations: shared decision making, who should get to decide, and communication. So this problem will probably arise at a very later stage when we have a certain framework, a legal framework. Now, we all recognize that this question is as much medical and ethical as legal it is in nature. So let's say we have a law, and there can of course not be an exhaustive list of circumstances that may arise. So in a case where we have a law, is it advisable, and if yes, possible, to have a pecking order or hierarchy of decisions? Because in a situation where, let's say on a battlefield, someone is suffering, it's not logistically possible to first get an approval from the appropriate authority, get him treated with a doctor. So, and there will be situations where the action of euthanasia is legally permissible but not desirable by the caregiver, or if it's not legally permissible but advised by the medical community, and in certain situations, like we acknowledged, the desires of the sufferer can't even be communicated anymore. So is it advisable to have a certain fixed hierarchy on whose decision in cases of conflict of decisions will supersede whose decisions?
I'll let the doctors talk about what this would mean practically. So, and then maybe I can give my perspective as a lawyer. Parth, do you want to take that?
I am personally not very, very fond of guidelines because, they are not applicable in each scenario. The decision ultimately has to be socially, culturally relevant in that context. And to have a very rigid hierarchy would complicate things more, in my opinion. So it depends on the communication you're having at that point of time, because it also is a lot of, at that heat of the moment, what people are thinking is very different from when they are calm. So ideally, that's how AMD helps, because at that point you're very calm. For example, when I visit homes now and I ask relatives or the patient that, would you like to get intubated if you fall sick tomorrow? And they say, "Mujhe maaf karo." Then I ask the son, "Did you know this?" And they're like, "No, we didn't know this." So this conversation needs, and it's not like that's a one-point conversation. It has to happen over and over again, and that needs to be sort of incorporated in our culture as such. So I don't think a hierarchy would be useful in this case.
And that's why you have an AMD where actually the patient does get to nominate someone who they want to take that decision on their behalf. So that's one thing in favor of executing one. Now, if that AMD doesn't exist, the law can theoretically endlessly prescribe a hierarchy, but it's of no practical use because you can't ensure that something like that will be followed in all circumstances. So at the most, there can be guidelines or suggestions to guide doctors so that they feel protected as far as their own liability is concerned. And a practice that, now we see, for example, in UK legislation is that you have a law, but you also have an accompanying code of practice, which gives guidance to the people who have to administer the law on what they should do in scenarios like this. Again, it's not binding because it's not useful to make something like this binding, but it is a way in which the law can provide some direction. Yes, ma'am. Oh, sorry.
I want to address this. This is a very important question because to give the battlefield example. Now, emergency situation. Now, somebody in the last legs, terminally ill comes to the emergency. You can't have all these two panels and all these procedural handicaps. So the answer is not to have a hierarchy of situations. The answer is to have a workable procedure which is applicable across the board. Now, having two panels makes it unworkable. So you must have only one panel and two or more physicians. If it is simplified, to keep the principle of collegiate decision making, not an individual decision making, and that is a safeguard in itself. So to keep the safeguards intact and not deprive its applicability across the board, because this is a very common situation. In the emergency room, you might have to take a decision, and which we do. So, which we do having two or more physicians, and also documentation. So documentation shows transparency, and then you have the reasons thereof, why you're taking the decision. So those sort of procedural simplification is the need of the hour.
Absolutely. Ma'am here, and then the gentleman on this side.
Thank you, and my name is Shruti. Thank you. I teach law in Jindal University, and this is really fascinating, and thank you. I have a question about, I'm curious, so I'm sorry I've not read the judgment, and I'm also just thinking along. I'm wondering, how does this intersect with the disability rights? Because disability is not, we know that disability is a combination of medical and social considerations. And in the disability rights movement, there has been a very fierce struggle for recognition of legal personhood and autonomy, because there's infantilization throughout their lives. They are struggling for right to be born. And that's a conversation between the abortion and disability rights. How are their interests, special vulnerability, how are they protected in this debate? I'm curious to know about that. Thank you.
I mean, from the perspective of the judgment itself, there is no specific mention of something like this, but maybe the panelists can talk a little bit about how doctors make assessments about a reasonable quality of life, because this is where the intersection with disability rights is, comes into play the most, and there are value judgments made which are, patently discriminatory. So maybe Parth, Dr. Sushma, you can talk a little bit about this in the context
of... in this, I will say that quality of life means it should be meaningful quality of meaningful life. Actually, if you think that the quality of life which is going to be, which I'm going to provide with this treatment is not going to be meaningful, I don't think that is required, and that gives a very good, absolutely clear answer.
Yeah, I had one patient when I was in emergency. She was around 20, late 20s, and she had severe physical and intellectual disability. And I could see her and make out the family was not taking care of her. She had long grown nails, she had probably not taken a bath in days or months. And she came in with a severe pneumonia, required ventilation and antibiotics. And that time we had to take a decision of, because is it right to give that medical treatment and send her back to the same house where she'll probably come back with the same illness? So the law doesn't outline it, but as doctors, again, if we follow the four principles of ethics, we can take that decision at our level. And again, I don't think we have to approach the court for this. At the ethics level, we can do that.
You see, when we talk about the quality of life and meaningfulness of life in a disabled person, the meaningfulness as judged by the person or by the person close to them, that has to be assessed. That has to be elicited. We can't take that call. I mean, the physician, it's not for the physician to take that call, though it can come in the discussion. The physician can bring it to the point of discussion. Whether prolongation in this state will lead to a meaningful outcome in terms of the family or the disabled person's perspective. No, if it is possible to elicit that from the disabled person, that is best. Second best is from the family close. If you think that, as Parth said, the family is not looking after, or there's prejudice in this by the caregivers, then the physicians have to take a call themselves. Okay, 2 or more physicians will take a call, whether it is meaningful or in patient's interest. The best interest call has to be taken by the physicians themselves if you suspect foul play by the family.
Hi, my name is Gaurav. I practice law in the Delhi High Court. How do I ensure that my AMDs, when required, are available for the doctor? Because it should not happen that I have an AMD and everybody is running around. And also, is it a simple checkbox that I have AMDs, or it's like a will that I have to dictate to my lawyers, I want this line, this line, this line, and that is how the AMD should look like?
Sure. No, I mean, there are some key elements that the court has said should form a part of your AMD. We do have, I think, some sample AMDs out there for, anyone who'd like to take them and use them for their own purposes. And the law requires that for it to be a valid document, it should be executed before a notary or a gazetted officer and signed by 2 witnesses. So these are the minimum requirements for it to meet the procedural formalities. Now the question about how your doctor will be able to access it. One is, of course, you should give copies of it to the persons you have nominated in your AMD as your healthcare proxies, and hopefully it will be one of those persons who brings that AMD to the attention of the doctor. The other things that the court has said about AMDs, are theoretically fine and are intended to allow an AMD to be accessed in this manner. One is that it should form a part of your digital health records. Now, there's currently no provision for doing that. But presumably at a point when that is enabled, you will go to hospital, that will pop up in your digital health records. Those records will be interoperable across hospitals and everyone will be able to have access to them. But the mechanics of that are not in place yet. And the third is that you're supposed to send a copy of it to the custodian, who is an officer appointed by your local authority. So a municipal corporation, a council, a panchayat, whatever the relevant local authority is. And again, I think the thinking that the court had in mind here is that doctors should be able to verify your AMD by reference to that local authority. But the process of how that will work in real time is still something that the government and the administration needs to work out. So ideally, yes. If you have a family physician, share a copy with them, share a copy with your nominated healthcare representatives, and make all your loved ones know about the existence of it, so that it is accessible as far as possible when you do have to go to hospital. That's a different kind of pledge. There is a pledge you can make under the Transplantation of Human Organs and Tissues Act. But again, over there, you do require the consent of your relatives before, even if you have made the pledge for your organs to be donated. Yes, please.
I just wanted to say that I don't think the issue of quality of life and suffering is a medical problem, a legal problem, whatever. Let's not think of it. It's a problem, human problem, and we are all responsible. Society is responsible. The government is responsible. People with disabilities, the parents have said, yes, they're leading a wretched life before. They didn't know there were schools where they could send their children. They didn't know that there was counseling that they could receive to help them understand how to look after these children. And then that there was the possibility of building the child's potential in a beautiful way. You see, but if you don't provide these things, if you don't provide even palliative support or care, then life is wretched. You will see suffering and you'll say, please, I don't want to live anymore. Finish me off. Loneliness. That's a big problem now. in the Western world. People don't want to live because they are lonely. So there again, what is the responsibility of society? What is the responsibility of the family towards the elderly? Should they be providing them spaces where they can meet each other, where they can feel valued, where they can where they're able to do physical exercises, deal with other problems? So, it's a very complex issue. It's an issue that we, if we want to call ourselves a civilized society, have to address. Otherwise, the answer is going to be, and the answer is not that, give me an injection, a lethal injection, and put me out now. And sadly, that will become the preferable route in time to come if we don't address these issues now. That's why it's very, very crucial for us all to be able to understand what is driving this. And each one of us play that role of compassion, of communication that was talked about very wisely, because only then will we really get to the heart of this problem. We have seen it in our work, people who didn't want to live once their concerns were addressed, once there was compassionate care, once their pain was addressed, are quite willing to live on. And the whole idea should be live as a normal life for as long as you can. That should be where our emphasis should be, especially today where we are living longer and longer. That is such a real human need. So I feel that this is also an aspect of life that we must not lose sight of. The answer is not just a medical answer. The answer is not just a legal answer. It's much more than that. It's an answer of our human values. How human are we? That's where the answer lies.
Very much.
Sometimes in the case of women in death, related to the patient themselves, mukti mil jaye. They wish mukti mil jaye. They are not able to express it.
Oh, scared.
Just a small, yeah, sorry.
Sorry, who's the
Okay, just a small follow-up to the disability-related answer that the panel gave. So, my question is pneumonia ordinarily considered a life-threatening disease? Parth sir, to you.
Yeah, if it's extremely severe where the infection has spread into the blood and has caused damage to other organs as well, it can be life-threatening. So, sir, I want to understand that since you said that physicians will decide in cases families neglect, and families neglect a lot of times, especially in cases of persons with mental health illnesses. Most of them just want to get rid of them, especially sometimes persons with mental health illnesses also get very violent and all, and it's unpredictable. So in those cases, would the standard that you have for saving an able-bodied person be the same as like in the case of a person with disability? Will the standard be the same? For example, if I were to have like a cardiac issue, for example, in which I can be saved, but it's a little difficult to save me. So will the standard vary, like across able-bodied and like a person with mental health illness, for example? I would say it would depend on the scenario. This particular patient came during COVID, during which time even the social support from the communities had shut down. And if it is possible to find help in the community through non-profits or other organizations, that would be definitely the route. But as we know, access to these kind of services also is quite limited in our country. Mm-hmm. So I think again, ultimately, it depends on that particular scenario. I wouldn't say there are defined goals pre-hand which we can follow, but I would say it depends from case to case.
Okay, thank you, sir.
In a given case of pneumonia, treatment of a disabled person and a not disabled person is exactly the same. But the scenario that Parth was alluding to is, in the extreme terminal illness stage, okay, the disability is part of the comorbidities. Now, in that situation, how does prolongation of life help the patient? That is the question. Disability doesn't change the medical outlook. Okay, it's the same. Whether you're disabled or not, treatment of that condition, if it is possible, will be possible.
One last question from the gentleman in the back, and then we'll close for today. That's a great note on which to conclude. So maybe. Yeah, that's why we're here. That's why we're discussing this, and we have. Yeah, please. I want everyone to answer that actually. So, and we'll end on that note.
So the problem is, a lot of the time, this discussion doesn't even happen in the family. Creating a living will just facilitates that discussion where the family members know what the values of the person are when it comes to death. Like I mentioned, when I ask people, do you want the living will? They say yes. Then I ask them, would you want to get intubated if you were to fall sick, extremely sick tomorrow? They say no. And now the family knows what they want. Ultimately, when somebody falls acutely sick and this discussion hasn't happened in the family, at that point the family thinks the best we can do for this person is to save them. And is to do whatever we can to save their life and prolong their life. But if this discussion can be facilitated through an AMD, I don't think the legal structure is even needed at that point.
Yeah, I think the law is a starting point, is a catalyst, as we mentioned earlier, for some of these conversations that were not otherwise happening. Dr. Sushma and then Dr. Mani, where do we go from here? What's the conclusion?
I think the law will take that shape definitely. Someday will come when it will be very simpler. But the concept which will remain universal and which will always govern us is, because I can see that since the day I'm practicing medicine, not two patients are similar. But the principles, the way I treat my patients are same. That I am going to act in the best interest of my patient. I will neither prolong the suffering but nor hasten the death. I think when we will work on these principles, I think automatically all the problems will get solved. When we use these basic principles which we imbibe in our mind, and on the top of it, I will keep on talking that communication and compassion makes the huge difference in any circumstances. Not two circumstances will be similar, but communication skills and compassion will always remain the same. And when we use this universal principle, I think we will have a wonderful world, and there will be no confusion about this legal battle with doctor, patient, and it's like definitely rule will be very, very simple. But if we will not use this communication and compassion, I think again we will fall in a problem. And these universal principles we should definitely use throughout our practice.
Absolutely, Dr. Sushma. Dr. Mani, last words.
See, where do we go from here? The best case scenario is that whatever we have now is the simplification of the 2018 judgment, and the mechanisms prescribed there has to be put in place by government agencies. It is not the best of procedural guidelines, it's still complicated, but it's a beginning. There's a cultural shift at least. We are thinking about the terminally ill, the dying, the needs of the dying, the imposed sufferings, avoidable suffering. We are thinking about them. And this discussion has come about in the wake of this judgment. So if the mechanisms are in place and there is guideline from the government, there is a guideline from the Ministry of Health which was uploaded for public comment in September, and they will be in their final form soon. They will be published. So this will be a harbinger for change, on the ground. This should be followed up by the mechanisms being facilitated for example, identifying the custodian, the methodology for verifying AMD, genuineness of an AMD, and then how to put in place the panels as recommended by the Supreme Court. But going forward, even better would be simplification of the process further. We have come only halfway. And going further, there should be more public physician interaction, and then judiciary-physician interaction to understand what the scene on the ground better, and then formulate procedural modification going forward, and if possible, have a legislation.
Thanks. That's very clear, Dr. Mani, and a great roadmap for the way ahead. I'm just thank you very much, everyone, for your engaged participation through this evening. It's wonderful that you were able to come and have this conversation, and we do hope that you have this conversation with your loved ones as well. If there's more that you would like to know about how to make an AMD, there, as I said, there are some templates out there. Do visit the Vidhi website, the Palliative India website. All of these have toolkits on understanding what the legal framework says a little better, as well as using these yourselves. You want me to write to the email? Yeah, so please, if you have any queries, do write to advancecareplanindia@gmail.com. We'd be very happy to answer any questions that you might have about this process. From my perspective, I think this is not an issue, as we said, it can't be seen solely through the eyes of the law, solely through medical expertise. It is a social issue, it's an ethical issue, it's a humanitarian issue, and all of these disciplines have to learn to talk to each other if we have to have a workable solution going forward. And we think that this case is the start of this kind of conversation, and we hope that we will hear more from all of you on your experiences with, interacting with this, implementing this, and from that we can build something that everyone can work with, understand, and that makes sense in our, socio-economic context. So thank you very much. Continue to have the conversation, and thanks for being here.